So, good afternoon and welcome to this event organized by the TTIP and the Center of European Law. As you know, the Center of European Law is involved in the Jamone network TTIP, discussing legal ambiguities about international trade, investment, and of course, TTIP. So today we have Flavia Marisi from the Chinese University of Hong Kong. She actually lectures investment arbitration at the university, and she is an expert in transparency in investment arbitration. So today she'll be here for this lunch seminar, and of course we will have this lecture, and then feel free please to interact with questions and to have a discussion on this actually challenging and topic of law due to the many situations, many events that we have all around the world and discussions about investment arbitration. So I leave immediately the floor just to Flavia that we start our lecture.
Thank you very much, and thank you all for being here. Today we're going to talk about transparency in investment arbitration. I would like to start with a question to you. What is the case AAY versus AAZ? Have you ever heard of this case? Anybody? No. Can anybody tell me what type of case this is? Who the parties are? What the matters at issue are? No. Why is that? Because it is a commercial arbitration case. It was administered by the Singapore International Arbitration Center. And if I can guess your reaction when I told you about this case, I guess that it was like this. So we're all a bit crawling in the fog with commercial arbitration cases. And why are they different from investment arbitration cases? What are the similarities and what are the differences of commercial arbitration versus investment arbitration? Can anybody tell me the similarities and the differences? You have seen 1 second of the next slide. Maybe you remember something. So let's look at it together. So what do these two types of arbitration have in common? So first of all, they are both consensual. So they find their base in an agreement, in the agreement. That can be the agreement of the parties to the arbitration, as it happens in the commercial arbitration, that sees a company, or in any case a private party, against another private party. Or the consent may be based on a treaty signed between the home state of the claimant and the respondent state. So this is something that they have in common. They are both consensual. Then, regarding the selection of arbitrators, in both types of arbitration, the parties can appoint their arbitrators. Usually, one party selects arbitrator A, the other party selects arbitrator B, and then these two arbitrators appoint the president. Another similarity is that the award is final and binding. So it is binding for both parties. And there are limited grounds for review. The appeal is currently not foreseen, and the review can happen only in very limited cases. Regarding the procedural rules, they are similar, but they are administered, they could be administered by, for example, administering institutions. So let's mention the ICC, for example, or the ICSID, or the Stockholm Chamber of Commerce, the London Court of International Arbitration. These are all administering institutions. So we talked about the similarities, but what are the differences? So why do you find here in the slide that the nature of the parties is different? So what is the nature of the parties in commercial arbitration? I would like this class to be interactive, so don't feel afraid to have some ideas or thoughts. You're not going to be judged for that. Yes, correct. So while in commercial arbitration, the parties are private parties, both parties are private parties, in investment arbitration, one of the parties is a state. Who is affected by the award? So in commercial arbitration, only the parties to the arbitration will be affected by the award. But what happens in investment arbitration? Who is affected by the award in investment arbitration? Is anybody that is affected that is beyond the parties participating to the arbitration? Yes, so the ones that are affected by that measure, by the state measure? Yes, and yes, in general we can say that the population of the state can in many ways be affected by the award of the investment arbitration. Because of the type of measure that the state issues, because of the possible regulatory chill that might take place if the state fears to be brought before arbitration and therefore stops issuing new laws in certain areas. And also, why can we say that the whole population of a state can be affected by the award? So this means not only those that are the ones to which the measure is directed to, but the whole population. Why can we say that? Well, what happens in investment arbitration? What is a possible outcome? Or if we can ask, what does the claimant look for? Compensation. Yes. Yes. So the claimant looks for compensation for alleged damages, and if the tribunal decides that the state has indeed breached the treaty, then the state will have to pay a compensation, which starts from a few millions of euros or pounds. And this is why the state has to take these resources from its budget. Who has the right to sue? So in commercial arbitration, both parties to a contract, they have the right to sue. In investment arbitration, this is in theory the case, but in practice, it happens, in most of the times it happens that the state is the one bringing an arbitration claim against, that a claimant, the investor is bringing an arbitration claim against a state. Nature of or provisions allegedly breached. What happens in commercial arbitration, the provisions that are allegedly breached are the ones of a contract. But what provisions are breached in investment arbitration? Are they provisions of a contract as well? Any ideas? Yes, no, maybe?
Provisions of the treaty.
Yes, provisions of the treaty. Indeed. And the type of measures awarded, we already saw that in most of the cases in arbitration, investment arbitration, what is sought is the compensation. Now that we have made this introduction about the differences of investment and commercial arbitration, and why are they important? They're very important because there is one core feature of investment arbitration that calls for the problem of transparency. So should investment arbitration be transparent or not? So today we're going to talk about the concept of transparency. What is transparency? What types of transparency are there? Is there more than one type? What are the advantages of confidentiality, and what are the advantages of transparency on the other side? What are the transparency provisions? Exactly what are we going to regulate here? And finally, we're going to deal with a few cases that you can see here. So it's Aguas del Tonari versus Bolivia, Bywater Gove versus Tanzania, Pacific Cream versus El Salvador, and Bernard von Petzelt and others versus Zimbabwe. I have a second question for you. Has anybody heard of this other case? I know you haven't heard of the first case, but I'm curious to know if you have heard of this case, Vattenfall versus Germany.
I have. I'm a Swedish taxpayer, so
So
in my interest.
you're very interested in that. Yes, so why does Sweden come into play here? Because Vattenfall is a Swedish state-owned company. However, the fact that you are a taxpayer doesn't really come into play. Are there any Germans here? No. Because in this case, the Swedish state-owned company brought Germany before an arbitral tribunal. So this means that in the end it would have been, as we will see, or it will be Germany that will have to pay. Anyway, of course, Swedes are interested in this arbitration. So why have, so are you the only one that has heard of this case, or some other people? No. Excuse me? What did you say? I didn't... Yes, yes. But why do we call it saga? Because there was not just one case, so we have two cases. There is Vattenfall versus Germany 1. And how do we know about this? So here you see, do you see the slide? The news of the Spiegel online of 2009. Power plant battle goes into international arbitration. So here in 2009, it was not yet about nuclear energy, but it was about a coal power station that Vattenfall had built in the nearby Hamburg. The Vattenfall brought Germany before an investment tribunal on the basis of the Energy Charter Treaty, claiming that Germany had indirectly expropriated Vattenfall itself of its assets. what happened? Here we see another news of 8th of June 2012. But this is already Vattenfall versus Germany 2. So what happened with Vattenfall versus Germany 1? So the case went on between 2009 until 2011, and it was settled. If I ask you, can you find the settlement agreement online? Is it available? Then you will probably say, no, this is impossible, because it was not published, the content of the settlement agreement. So there was an award that makes reference to the settlement agreement, and it was just said that a modified water use permit was issued by Germany to Vattenfall with less stringent environmental requirements. This is everything we know about Vattenfall versus Germany 1. In 2012, Vattenfall brings Germany again before an arbitral tribunal. And why? This is the case that regards nuclear power. So what happens? Vattenfall had built a nuclear power plant, but Germany approved the 13th Amendment to the Nuclear Act about the phasing out of nuclear energy by 2022. So if we think, we can say 2022, that's a lot of time, but this is actually one of the core differences between trade relations and investment. Because if we think of trade as a purchase of goods that happens in one precise moment, we should think of investment as a longer project. So in investment, companies invest millions of euros and they expect a return maybe in 20, maybe in 30 years. So this is why the phasing out of a nuclear power plant by 2022 didn't really make Vattenfall happy with Germany. So this is the news that we can see here. How much money does Vattenfall seek? Vattenfall seeks 6 billion in compensation for German nuclear phase out. And this is another news of the 27th of October of last year, 2017. US ruling on Vattenfall's German nuclear case expected next year. But let's remember that US ruling does not point to a US court, but it points to the ICSID tribunal that has its seat in Washington. But this doesn't mean that it's a national court. So what do we understand from these news? From these news regarding transparency, we understand that at least the mere existence of an arbitration was public, also in Vattenfall versus Germany 1. However, we don't have much more detail about Vattenfall versus Germany 1. But what is the groundbreaking news that we find in Vattenfall versus Germany 2? So in 2016, the parties consented to the hearings being broadcasted.
Tribunal. I was almost using another expression which is common in the United States, but I will refrain it in light of other discussions we have in this country. But this is a tribunal that has read the files extensively. For weeks we have been studying this. So don't think that we are a cold bench. We have read it, And if it's in that perspective, we would like the parties to invite them really to only to focus on the major issues in the opening statements. And that also would then translate into being economical with the time allotted to you, so that we can advance with the case with expediency as required. Length, may I remind you, the length is maximum 3.5 hours, is 210 minutes. Mr. Colbert, Professor Colbert, I think you're the first one to start. Your time starts now.
Thank you very much. We have prepared opening bundles for the tribunal and of course for the other side. So I'll just wait for them to be distributed.
Sorry, can we just make a note for the record? It's good custom that to give bundles and materials to the other side first and only then to the tribunal. And I think we should abide by this rule in this arbitration.
So what do we see here? We saw the room where the hearing takes place. We see the presiding arbitrator welcoming the parties and saying, we're not a cold bench, we have already studied the case, so please go straight to the point, don't go around in circles. And then we see counsel for respondent, a lawyer in red, asking for a procedural matter, just that the bundle be given to the respondent party before and then to the tribunal after. But this overall, what we can see here is how the arbitration hearing takes place, develops, what happens in the arbitration. These videos are still available online. So they were broadcasted, they were live streamed when the hearings took place, but still, if you're interested now, you can find these hearings online. And why is it so important? Why is this case so important? Because in Vattenfall versus Germany 1, we have the most complete confidentiality. We don't know what happened. But in Vattenfall versus Germany 2, the hearings were broadcasted and they're still available online. So we see a complete switch in the policy regarding transparency in the conduct of these arbitration cases. And so we can hope that such a change may be possible also for other cases. Now, after this very long introduction, let's move on to the concept. What is transparency? Any idea? What does it refer to? What are we talking about? What should be transparent in investment arbitration? Don't be afraid. Just you can point out anything.
Decisions are made, how much is paid out by the state proceeding. The state is in the domestic court, I suppose. It's in the openness around the process of the decision.
Sir, can you raise your voice? So how much is paid by the state? You mean as a compensation in the award?
It's about openness in the proceedings, openness in the decisions made, what are the decisions made by the state, how much is paid out. Some of the considerations to the web to court, that's all open and available to the arbitration.
Yes, yes, exactly. Yes, openness is indeed a key concept for transparency. So let's read this definition. Transparency means adequacy, accuracy, availability, and accessibility of knowledge and information about the policies and activities of the regional investment law regimes and its participants, and of the central organizations functioning within it, on matters relevant to compliance and effectiveness, and about the operation of the norm, rules, and procedures underlying the regime. So this definition encompasses both regulatory transparency and procedural transparency. What is regulatory transparency? Regulatory transparency is the transparency of laws and regulation. What does it mean? So while negotiating an investment treaty, the two countries that are parties to the negotiation, sometimes they include this provision, the provision of regulatory transparency. So they commit to publish and make available to the other state any laws and regulation that they are going to approve that might affect the investment of the investor coming from the other state. So this is regulatory transparency. Regulatory transparency lies within the treaties, and we're going to discuss treaties more in detail tomorrow. In this lecture today, we will focus on procedural transparency. What does procedural transparency mean? It concerns several aspects of investor-state dispute settlement. So we are just talking about investment, the procedure of investment arbitration. Should it be transparent? Should it not? Should it be transparent partially? And how? Who decides? Who should have the power to decide? This is a topic which is highly debated, as you can imagine. Now, after discussing the concept, I would like to ask you about the advantages of confidentiality. So let's always imagine that we are within an arbitration. So in this, why do parties choose arbitration usually? Usually arbitration is one of the main reasons why parties choose arbitration as a means of dispute resolution is indeed confidentiality. But why? What are the reasons?
Let's say the risk of background, and also to keep, for example, in commercial arbitration, to keep trade secrets and possibly sensitive details about your company confidential.
Yes, very good, exactly, yes. So confidential business information. Something else? Would you be concerned if you were a company about your reputation? Or maybe even if you're a state, would you be concerned about your image in the eyes of your people? Right? In some cultures, being embarrassed is really to be avoided, especially to be embarrassed publicly is not the case. So can we think of something else? So we said to protect confidential business information, trade secret, reputation of both parties. You mean within the arbitration?
If you want to negotiate a settlement.
A settlement. Mm-hmm. Yes. Flexibility during the settlement.
Yes.
Let's say.
It's confidential, so it's not third-party involved.
Yes. So it avoids public scrutiny, right? So taking out the dispute out of the eyes of the public allows for more flexibility. We can arrange it in a more flexible way. So let's, yes, this was the exercise, critical analysis. Let's recap. Protection of classified business information, reputation, maintaining a good and stable atmosphere that continues to attract FDI. So the first two, protection of classified business information and reputation, they pertain more to the investor. But maintaining a good and stable atmosphere that continues to attract FDI, this pertains to the state. So sometimes we forget to think of why the states in the first place enter into investment agreements. So they want to attract FDI, they want to attract foreign direct investment, they want to have inflows of projects coming with technical expertise, know-how. They want the provision of services that they are not able to manage, for example. If you think, in some cases we will see further on, many of the cases of investment and environment, they regard the provision of water. And for the provision of water, you need technical abilities that some countries might not have. And if a state is brought before an arbitral tribunal because it has allegedly breached a treaty, doesn't this represent a threat for all the other investors? Don't the other investors think, well, the state behaved in such a way, it has approved this measure that harms the investment of this other investor, so I might as well not invest in this country anymore, maybe shift my focus to another country where the legal regime and framework is more stable regarding my investment. I heard that there is an Argentinian towards you. Probably you have heard of the many Argentinian cases. So why are we talking about this? Reducing the probability for other investors to bring similar claims. I'm sure you have heard of the Argentinian financial crisis. In that respect, Argentina issued state measures that impacted the investment of different investors. And what happened? They brought different claims all against Argentina. So these were all different arbitral cases, all against Argentina. So maybe an interest of a state could be to keep it confidential, to keep this claim confidential, in order to reduce the probability for other investors to bring similar claims. So this is political, also from the state's point of view, getting the approval of stakeholders. Are you interested in being re-elected? Maybe you want to get the approval of the stakeholders. This is something that you pointed out regarding the external pressure, keeping at low level the external pressure on the procedure. We know, we have seen already in national, I would say mostly national criminal law cases, that when a particular proceedings is made public and the media talks about it, then there are external pressures on the judges to make a certain type of decision, and it is not always pleasant. It does not always lead to the best decision. This is concerning culture in some parts of the world, especially preventing high governmental and company officials from suffering any embarrassment could be very important. Safeguarding sensitive national information. This is mirroring the protection of classified business information for companies. Not hindering the collection of evidence. Also, this could be a problem. And these are all the advantages of confidentiality. What reflection can we do on these advantages of confidentiality? How can we divide them? So if we want to group them, we can see that some of them aim at safeguarding the party's interest, while others aim at protecting the arbitration system as a whole. enough about the advantages of confidentiality. Now we talk about the advantages of transparency. What is in your mind on this? Why should we? Let's remember that we are dealing with investment arbitration. So in investment arbitration, there is an aspect of public interest. So there is public interest. Why should investment arbitration cases be public? Why should they be transparent at least?
To support the fairness of the awards.
To support?
The fairness of the awards.
The fairness of the award.
So many countries, developing countries, in Argentina, sometimes the requests occur to go to arbitration because they always believe that they're biased by developing countries. So developing countries don't like to go to this tribunal. But they always are supporting the investors and like that.
So in hope that the decision of an impartial, third, neutral, arbitral tribunal would be less biased than the decision of a national court. Yes, definitely, and transparency can add on this if the award then is made public. Then the same arbitrators that are selected to be neutral, impartial, they are then accountable. So yes, that's a great point. Other points?
Public can feel more confident that decisions being made. That's what a court process is.
Yes.
Court processes are open, so that you feel more confident in the decisions being made.
So would you say that it's legitimizing the system? Yes. Yes, very well. Yes, so let's, we will find these 2 points. So the first point is good governance. So good governance, as you can see, these are all parts of good governance. Transparent is part of good governance, and this means that transparency brings good governance. It is, this is part of it is a shared opinion that it is essential that the administrative and legislative entities should be as transparent as possible with everything that regards their relationship with the citizens. So good governance, number one. What does this picture make you think of? So these are corporate people with a tree replacing their heads. This is corporate social responsibility. So why are companies interested in corporate social responsibility? Reputation, yes, exactly, reputation. And why do they care about the reputation? Because the consumers nowadays, they vote with what they buy, and they choose certain types of companies depending on the values that these companies promote. So this is why companies are interested in having a whole field department in their structure dedicated to corporate social responsibility.
Could they just not choose arbitration if that's what they want, full transparency? Could they just decide to do court instead of
Yeah, this is a very interesting question. The type of dispute settlement depends on the treaty. So the company that has made an investment in a foreign state and that has allegedly been harmed by a measure of this foreign state can find its means only in what the treaty says. And the applicable treaty is the treaty between the home state of the investor and the respondent state, so the host state. It depends on what the treaty says. If the treaty says that the parties should go before a national court as a first step, then that's the procedure. If the treaty says that there should be a period of 6 months of mediation, then this is the procedure. It's the treaty that decides the procedure. The company does not decide what is the forum that is competent to decide the disputes between the company itself and the host state. What is another advantage of transparency? Contributing to the evolution of the case law. So here, this pertains to a particular aspect of transparency, that is the publication of the award. So if the award is public, what does it mean? It means that arbitrators of future cases can make reference to it. It's not binding. Previous arbitration awards are not binding for future arbitration awards, but the future ones can make a reference to the previous ones. And this is how it contributes to the evolution of a coherent body of a case law. This is the main challenge that we see in investment arbitration, that there are some decisions that are completely opposite others in the same cases. So for example, the Argentinian cases that we mentioned, there were cases where the measure was the same, the type of company of the investor was the same, so the type of service provided was the same, but the two arbitral tribunals reached two opposite decisions based on the definition that they gave to the state of necessity, for example. In that case was the definition of the state of necessity. But if we have if we start to develop a coherent body of case law, then we will avoid in the future these contrasting awards. What do we see here? We see surgery. How do we need to be in a surgery? We need to be precise. So promoting precision in international law, what does it mean? If you have ever read a treaty and some provisions in the treaty, for example, the FET, has anybody read it? Yes? Some? No? Some yes, some no. So the fair and equitable treatment in its early days was a very, very broad provision. And basically it read like this. Each party commits to provide fair and equitable treatment to the investment of the other party. Full stop. This is it. Does it say what fair and equitable treatment is? What is fair? What is equitable? What is fair and equitable together? Is it different from fair and equitable taken differently? So if the award is published, then we will have access to the reasoning of the arbitrators, and we will have access to the application of the facts of the case to the norm, and we will see that they will define these vague provisions, that they will define them better. So this is what it means, promoting precision in international law. Creating confidence in the ISDS system. So you have pointed out to the legitimacy, and we will deal with it in the next slide, but the legitimacy concerns the people, how the ISDS system is perceived by the people. Now, regarding the confidence, we're shifting the focus to the states. Are states, the states themselves, the ones that sign treaties containing the ISDS provision with other states, are they confident in the ISDS system? Do they like it? So in this slide, you can have an idea of the countries that have started to terminate their BITs. BITs means bilateral investment treaties. So Nicaragua, Venezuela, Romania, India, and Ecuador, they all started to terminate their BITs. Brazil never has had any bit. And this is regarding the bilateral investment treaty. Regarding the ICSID, is it possible to withdraw from the ICSID? Yes, it is. Of course, there is a sunset clause, so it's not automatic from the moment that we say we don't want to be part of it anymore, but Ecuador has started this procedure, for example. And regarding ISDS in general, the Philippines and Australia have shown their interest in not having an ISDS clause at all in the future contracts, in the future treaties that they will negotiate. In Australia, for example, there was this anti-ISDS bill that was promoted by the Greens Party, but that didn't go through. However, this ISDS continues to be discussed in other parliamentary inquiries. So we see that there is political thoughts about having ISDS in investment treaties at all. So now we're moving to the legitimacy of the ISDS system. Here you can see one of the pictures that was used in the anti-TTIP campaign. I'm sure that all of you have followed the movement. So what does it say? Health warning still contains unfair advantages for foreign investors to sue governments for implementing worker, consumer, or environmental protections or defending public services. Let's look at the video of a protest.
Demonstrations were held in 7 German cities to condemn transatlantic trade and investment partnership. That's the TTIP. The TTIPill protesters also signed a deal between Germany and Canada called a CETA, that's a CETA, that's set to be signed in October. Similar rallies were also held in Austria. Protesters say the agreement in no way serves the people's interests.
So has anybody of you spotted the mistake in this video? So there was a mistake. This is actually how the world sees Europe. This is an Iranian TV, but they made a mistake. So they said that the CETA is an agreement signed between Germany and Canada, but it's not. It's between the EU and Canada. So what does this tell us? So by increasing the transparency and involving the public in the dispute, at least making it available, then the legitimacy of the whole system could increase. And maybe we could avoid these protests. What is another advantage of transparency? So here we see a man in the weather forecast. Although he's trying to foresee what's going to happen with the weather, some unforeseen events like the dog jumping on him still happen. But this is what transparency can do, can increase the predictability of outcomes. So if we know how certain disputes are resolved, how certain provisions are interpreted, then we can predict how a similar case and how a similar provision would be interpreted in the future. Although we cannot be certain about it, but at least we can increase the predictability of the outcomes. This is something that you have mentioned already, improving the tribunal's accountability. Why is it important and why does it change? Does it change, in your view, does it change if decision-making is made in closed doors versus if it is made publicly, if the process is disclosed or undisclosed? Does it change?
Shouldn't really change the decision.
Shouldn't really change the decision, but
Perception, isn't it? I think more it's about how people perceive the process rather than how it actually is. The arbitrators don't
Well, that's a very optimistic view. Yes, very full of hope for the professionality of arbitrators, of course. And of course, we all hope that this is the case. But publishing the award improves the accountability of the tribunal. The last one is encouraging public participation. How can transparency encourage public participation? Can the public actually be present? Can take active part to an arbitration case? Let's think of an NGO, for example. So have you ever heard of amicus curiae? Yes, we're going to talk about it later in detail. What is this figure and how it works, how it is regulated in investment arbitration. Yes, the possibility for amicus curiae to participate in investment arbitration encourages public participation. So since there is a public interest that is involved, the point of view of civil society groups, of NGO groups or non-state actors should be taken into consideration. And they have a favorable impact on the arbitration itself. So let's review what we have just said. We talked about good governance, corporate social responsibility, contribution to the evolution of the case law, promoting precision in international law, creating confidence in the ISDS system, legitimizing the ISDS system, increasing the predictability of outcomes, improving the tribunal's impartiality and accountability, encouraging public participation. And now we're going to talk in detail about transparency provisions. Well, first of all, where do we find the rules on transparency? What are the laws, the sources of laws that regulate transparency? So first of all, we can find some rules in the investment treaties and in the arbitral institutions. So has anybody heard of the NAFTA? What is the NAFTA?
American Free Trade Agreement between the US and Mexico.
Very well. So what does the NAFTA say? The NAFTA is an investment treaty. So the parties' agreement or the applicable arbitration rules. So what does this mean? What does this mean? The parties' agreement, so the NAFTA doesn't provide for a mandatory registration on the initiation of the arbitration, but leaves it to the parties' agreement. So the parties will need to agree. Shall we publish the initiation of the arbitration or shall we not publish? The parties will agree to it. Or if there is not the agreement of the parties, then it is left to the applicable arbitration rules, which are either the ICSID or the UNCITRAL rules according to the NAFTA. What does CETA and TTIP say? They refer to the UNCITRAL transparency rules. The UNCITRAL transparency rules are the main novelty in the field of transparency. We have seen that that treaties that are now being negotiated or that are even being stalled, but in which one of the parties is the EU. In these treaties, we have seen that the EU tries to push for the adoption or the reference within the treaty of the UNCITRAL transparency rules. We will see further on what they are. ASEAN. So ASEAN, has anybody heard of this term? So it's the Association of Southeast Asian Nations. So here the registration of the initiation of the arbitration is restricted to non-disputing party. It means that only non-disputing parties will know about the initiation of arbitration. And the disputing parties have 30 days to inform them. In a study conducted on investment agreement concluded between 2010 and 2013, 36 out of 41 had no provisions regarding the registration of the initiation of the arbitration. The ICC, the International Chamber of Commerce, upon the request of any party, so if any party asks for the registration of the initiation of arbitration, then it will be registered and it will be published. And what the SCC is the Stockholm Chamber of Commerce. This is strictest in terms of confidentiality. So these rules, they provide for the strict confidentiality. There is no registration on the initiation of the arbitration. So here, what does it mean, registration of the initiation of arbitration? We're just talking about the mere existence. Is it public that a case exists between investor A and country Z? This is what we're talking about. There, in some cases, there is a registry which is public. In some cases, the publication of this initiation of the proceedings is strictly confidential. Now that we have talked about the initiation of arbitration, so let's assume that we know that a certain arbitration is existing. What about the procedural document? So first of all, what are the procedural documents? What could be the procedural document? So any procedural order, for example, or the statement of claim, the statement of defense, the expert report, the witness transcript, a legal opinion as well is a document. So how they are available to the public in these BITs, so Australia, Korea, Canada, Korea, New Zealand, Taiwan, United States, Uruguay. They are available publicly unless the parties otherwise agree. So there is very much a difference between the standard norm, that is the consent norm, and the veto norm. So here, the standard is that they are available publicly unless the parties otherwise agree. So the parties have to agree that they should not be available. I've been in Canada and Canada, Côte d'Ivoire. Here we see the push from Canada, obviously. If there is a state law ensuring that certain documents will be available, then this provision prevails over the treaty. For example, in Canada, Serbia, or in Korea, New Zealand. In the London Court of International Arbitration, the standard norm is confidentiality unless otherwise agreed by the parties. Now we move on to the publication of the final award. So it depends. Also here, it always depends on the treaty. So it is public, the award is public in Australia, China, Canada, Côte d'Ivoire, New Zealand, Taiwan. It is public unless disputing parties agree otherwise in China, Mexico, Mexico, Panama. What does the ICSID say about this? The the center shall not publish the award without the consent of the parties. So the parties need to agree for the award to be published. LCIA does not publish any award or any part of an award, not even a part, without the prior written consent of the parties and the arbitral tribunal. So here, LCIA needs to get the consent of the parties and the arbitrators as well. And again, SCC confirms its policy of strict confidentiality. Stockholm Chamber of Commerce shall maintain the confidentiality of the award, and the rest is not relevant to us. So now we move on to public access to hearings. We have seen the video of Vattenfall versus Germany too, but let's take a step back. In other systems, are the hearings public? So this is actually, according to the European Convention of Human Rights and the Universal Declaration of Human Rights, it is a human right to have a public hearing. What does the CETA say about this? The CETA says that hearings shall be open to the public, and also the tribunal shall determine the appropriate logistical arrangements to facilitate public access to such hearings. What does it mean? It means that it should, what could be these logistical arrangements? For example, a video recording of the hearing, a registration of the hearing, broadcasting of the hearing, live streaming of the hearing, making the videos available online. However, this is a problem. If the tribunal determines that there is a need to protect confidential or protected information, there should be arrangements to hold in private that part of the hearing requiring such protection. So for example, we have seen the video of Vattenfall versus Germany too, and I have also told you that if you want, you can find online the videos of Vattenfall versus Germany, but you cannot find the videos of every single day of the hearing. Why? Because some days have not been published, the hearings, the recordings of these days. Why? Because they were trying to protect confidential information. So this is an arrangement that the tribunal can make in order to protect some information within a very, very lengthy hearing. TTIP, the non-disputing party has the right to attend a hearing held under this section. NAFTA, what is super interesting is that in NAFTA, the United States and Canada, they wrote a pledge in which they affirm that they will consent and will request the consent of the disputing investors to open to the public a hearing. Also, it recommends that the tribunal determines the appropriate logistical arrangement for open hearings in consultation with disputing party. So what does it mean? It means that the United States and Canada affirms that they will consent because according to NAFTA, the public access to hearings depend on the decision of the parties. So here, the parties already affirm that they will consent to the hearing being public. But what does it mean if there is one state party missing here? Mexico did not sign the pledge. So what does it mean? It means that Mexico did not commit itself to request that the hearings will be public. So this means that for Mexico, it is not as important as it is for the United States and Canada that the hearings shall be public. What about the rules of arbitral institutions? Because up to now we were looking at the treaties. So, permanent court of arbitration hearings shall be held in camera unless the parties agree. Stockholm hearings the same, in private unless otherwise agreed by the parties. ICC, the standard norm is hearings in private unless approved by the parties and the arbitrators as well. Same thing with London. And the ICSID, what the ICSID say is very interesting. Unless either party objects, the tribunal may allow other persons to be present to the hearing. So this is here, while in all the other cases, the decision lies completely in the hands of the parties. Here, it's the tribunal. The tribunal decides to allow other persons, and the party can object to it. So this is the veto procedure. Now we move on to non-disputing party participation. What is a non-disputing party? This is a question, a real question to you. Do you know what the non-disputing party is? If you are lost, don't worry, because it depends on the treaty. So different treaties have a different definition of what a non-disputing party is. So for example, in NAFTA, the definition is a person or entity that is not a disputing party. A party is a treaty signatory country that is neither the respondent state nor the home state of the investor. So what does it mean? It means that there can only be one country at the time that can be a non-disputing party, because within the NAFTA, one would be the respondent state and the other one would be the home state of the investor, and then the third one would be the person that is the non-disputing party. But, for example, the interpretation of this word, of the principle, of the expression of a non-disputing party is different in the TTIP and in CETA, because for them, non-disputing party can be the home state of the investor. The non-disputing party is the party that is not, is a state that is not party to the arbitration, but it can be for example, if Canada is the respondent state, then the European Union can be the non-disputing party. And here there are some rules for the participation of non-disputing party. Now we move on to amicus curiae intervention. You have heard of the term amicus curiae. What does it mean? Well, it's written there. It means friends of the court. It comes from Roman law. And in Roman law, it was an amicus curiae, the passers-by without any direct interest in the case, that could intervene in a process on their own initiative, providing the court with information on matters of fact and law that was beyond the court's notice or expertise. For example, the death of a party, or the collusion, or a manifest error. So what elements can we identify here? Without direct interest and providing information on matters of fact and law that is beyond the court's notice or expertise. So there has to be an added value. This is the definition under Roman law. So who could be amicus curiae? So we should look for amicus curiae among non-state actors. Among non-state actors, we can find a variety of actors, but the ones that are most likely to become amicus curiae are NGOs or civil society group. In literature, discussion has been going on whether the European Commission could be an amicus curiae. Can the European Commission be an amicus curiae? So some commentators have pointed out that the European Commission has a direct interest in cases, as the result would impact the European Commission itself. Therefore, it cannot be an amicus curiae. This is a theoretical reflection. So what is the role? What is the role of amicus curiae? Usually it expresses the civil society's concerns about core issues related to broader rights. For example, private property, the free speech, the right to anonymity, social cultural values, environment, as we will see in the cases that we will discuss further on, public health as well. When there are cases that are related to the provision of water, if the company that provides water is not successful in providing fresh, clean water to everybody, then there is a matter of public health. Or a right of a specific social group. For example, there are indigenous communities that may want to be amicus curiae to bring the interests of their specific social group. Why is it interesting? What is interesting is the emergence in international law of the idea of civil society as an important participant in the resolution of investment disputes. So this is what the trend is now. So we know already the definition of externalities, the situations where the effect of production or consumption or goods or services imposes costs or benefits on others which are not reflected in the price for the goods and services being provided. So these externalities can actually be better taken into account if the civil society takes active part in an investment case. So now, what can amicus curiae do? What is their spectrum of action? What can they practically do? So they can submit written briefs. They can, in theory, of course, then it will depend on the applicable rule. They can have access to documents, and very important, they can respond to questions by the tribunal, because sometimes it's the tribunal that wants to ask a specific question to get some insider information. ICSID in Article 37, paragraph 2, defines what the amicus curiae should do. So it should assist the tribunal to determine a factual or legal issue related to the proceedings by bringing a perspective, particular knowledge or insight that is different from the one of the disputing parties. Perspective, knowledge or insight different from one of the party. Address matters within the scope of the dispute. This is super important. Why? Because in some cases, amicus curiae have not been admitted to participate, to submit their brief, because what they were suggesting was beyond the scope of the dispute, was off topic. And then show a significant interest in proceedings. What research has pointed out is that the amicus curiae should not just repeat what the parties have already said in their memos. And also, they should not extend the subject matter of the dispute. However, if a tribunal welcomes amicus curiae submission, and then amicus curiae participate and they actually submit a brief, is the tribunal obliged to take into consideration the content of what amicus curiae wrote? No. There is no such commitment on behalf of the tribunal. In some cases, the amicus curiae brief were not of assistance in deciding the case. Now, what are the benefits and what are the concerns of the participation of amicus curiae? To actually find them here, this is not a real question to you, because it's already written there. It's greater credibility to the mechanism of investment arbitration and contribution towards its future consolidation and prevalence. And this fights the legitimacy crisis that we saw before in the protests. It improves public interest protection. It raises the quality of an award and provides expertise and promotes accountability. If you can think of some concerns regarding the participation of amicus curiae. So one of the features of arbitration, we said that was confidentiality. The fact of allowing a third party to join the dispute may put risk in the concept of arbitration, of the consensual nature of arbitration itself. What is unilateral positioning? So if you think abstractly, would you think that the amicus curiae would align its position with the claimant, investor, or with the state respondent? This is a real question. Yes, yes, this is a risk. This is a risk. So if the amicus curiae aligns its position with the state, then it jeopardizes the balance that there is between the two parties in the arbitration process. So this is why the amicus curiae intervention should really provide an external point of view and not necessarily align completely its position with the one of the state. Why can there be costs and delays? Yes. Yes, exactly. So after the submission of amicus curiae brief, then the counsels of the parties are required to comment on the amicus curiae brief. So this means that they will have to spend time and money to write their comments. And this is why the costs and delays are raised. And also this is why some commentators have proposed that the amicus curiae deposits a sum that would allow to cover for the extra costs of the counsels of the parties for the response of them to the amicus curiae brief. And repoliticization and interference with the party strategies, it all comes to that balance or lack of balance that there is when a third party takes an active role in the arbitration. Here we can see a very interesting interview to Professor Donald McRae of University of Ottawa that talks about amicus curiae intervention.
Well, I think, first of all, the assistance can be either on a factual or a legal matter. And I think that there's probably an important distinction there, because a non-disputing party may well have expertise and factual information that would assist the tribunal. In one sense, it's a kind of an easier case to make if you're an NGO or you're a body that has particular knowledge that's relevant to this particular case of a factual nature. And one saw in the Uruguay tobacco cases of the World Health Organization and the Pan American Health Organization, both having substantial knowledge in the area, were given non-disputing party status. I think when you turn to legal issues, it becomes a bit more complicated because there are two things at play. One is there may be a perception, a public perception of legal issues that are relevant, but there may be a different perception in the tribunal of what is relevant to the dispute. And the question is, what would a non-disputing party have to say on legal matters that the parties themselves couldn't provide? And here I see in the cases a bit of a distinction between the approach taken more recently in the von Petzold case and the earlier approach in the Bywater against the Gulf against Tanzania. In the von Petzold case, you had a claim that had some relationship to lands that certain people claiming to be indigenous people said were their lands. And you had a claim by those indigenous peoples and a human rights organization say that they want to bring perspective of international human rights law and the rights of indigenous peoples to the tribunal. Tribunal took the view that these were not matters that were being specifically raised by the parties. There was nothing there in the case that said these issues, human rights law, and issues relating to indigenous peoples, these are not being pleaded by the parties. Therefore, you're asking to bring something on the law that is not, in fact, what the parties have argued. And one might see that as a focus on the issues that have been raised by the parties rather than looking at the broader general public interest in the case. And that may be appropriate because Article 37.2 does not refer to public interest. In fact, public interest was behind all of these, but doesn't find its way into the wording. The public concern and public interest was one of the reasons for non-disputing party submissions, but didn't find its way into the wording of Article 37.2. And you might compare this with the earlier Bywater case, where the petitioners for for non-disputing party status wanted to talk about environmental law, and they wanted to talk about water resource management. And the claimant said, but those are not the issues that we've been raising in this particular case. And the tribunal said, yes, but this kind of information might well be of interest to us as a tribunal, and therefore we are prepared to hear what is being said by the petitioners. So on the one hand, you have a focus which is very close to what the parties have specifically argued. On the other hand, you have a focus that takes what the parties have argued and then looks at the broader perspective that might be involved. And I think we'll have to wait to see how subsequent tribunals, whether they go in the one direction or the other in looking at these kinds of cases.
So this is a very, very interesting interview to Professor McRoy, and he mentions two cases. He mentions Bywater Gulf and he mentioned von Petzold, and we're going to talk about them right now. Before moving on to the cases, I would like to finish the part on the transparency provisions with what I have already mentioned to you a few minutes earlier, the ancestral transparency rules. So the convention, they are based on the Mauritius Convention on Transparency, and they apply to investment treaties concluded before 1st of April 2014, and regarding cases that commenced after the convention enters into force. So what are these rules, the ancestral transparency rules? And we have already seen that the treaties that the European Union has negotiated and is negotiating include a reference to the antitrust transparency rules. So there is a publication of information at the commencement of arbitral proceedings. So the notice of arbitration is public. The documents, they are not all public. For example, the witness statements are not public, but what is public is a witness list. Submission by a third person is possible, by a non-disputing party to the treaty is possible as well. There are exceptions to transparency to protect confidential information. The award is public, and also there is a repository of published information where all this information can be found. So this is Mr. João Ribeiro. This is the head of Ancestral for the Asia Pacific. And in this interview, he sums up why the ancestral transparency rules are so important. The question is for Asia, but the truth is that their effect is beyond Asia, is global.
Well, the rules on transparency are important for states because it enhances the legitimacy and accountability of the process. It's also a sign of good governance and of fight against corruption. It will allow also states to justify when they have to pay damages, for instance, and they have to justify that expense within their parliaments. It's also good for people and for practitioners and for legal education because it gives access to several aspects of the dispute, of the proceedings, of the arbitral award, of the experts. It gives access to hearings. So it will kind of introduce a little bit of the principles of open justice to ISDS. And I think if people can recognize how the procedure is going and can understand how the proceedings are being conducted, that will add legitimacy to the process.
Very well. Now we talk briefly about these 4 cases. So first of all, Aguas del Tunari versus Bolivia. So this is a case of 2002. And it arises out of a concession contract for the provision of water. As we have already mentioned earlier, in many of the environmental cases, investment arbitration regard the provision of water services. And the city is the city of Cochabamba in Bolivia. The claims arise out of alleged actions and omissions of the government of Bolivia, leading up to the rescission of a contract agreement entered into with the claimant. It was governed by the exit rules. So first of all, we have to say that it arises out of privatization of water infrastructure. The water infrastructure first was public and then was privatized. There was a 40-year concession to the company Aguas del Tunari, and which brought to higher rates for the provision of water. And this, in turn, brought to protests. What you see in the slide here is a bunch of protesters tearing down the sign of Aguas del Tunari. Unfortunately, this is also called La Guerra del Agua. And this is just to give an idea of how felt this issue was. You can see on the slide a list of the petitioners, so it's not only one petitioner that wanted to be an amicus curiae, but several of them. And what is here we can find the decision of the tribunal. What does the tribunal say? The core requests are beyond the power or the authority of the tribunal. The consensual nature of the arbitration puts the control of the issues you raise with the parties. So this means that the tribunal does not have the power to join a known party to the proceedings or provide access to hearings to the public generally, or make documents of the proceedings public. What we have to remember is that this was an exit case, And according to these rules, if the consent of the parties is not present, as it is in this case, then the tribunal decided that they did not have the power to allow for the participation of the petitioners. And moreover, the tribunal added that there was not even a need to look for further witnesses or seek supplementary non-party submissions. And therefore, the tribunal decided to maintain the confidentiality of the proceedings. Another case, other protests, Pacific Rim versus El Salvador. So the investment of Pacific Rim took place between 2002 and 2008, and it was on a mine. In 2008, El Salvador banned metallic mining, and Pacific Rim applied for an environmental permit, but did not complete the feasibility study. There were huge protests in the population, and because of the fear of pollution. What is interesting in this case is that it was the tribunal that asked for submission. This is why this case is interesting. It was the tribunal that asked for amicus curiae applications. And even it gave a deadline, and within that deadline, nobody had applied. So in the award, in paragraph 1.24, you can read that no such submissions were received, and no applications were received by the tribunal pursuant to its order. However, later on, so after the deadline that was given by the tribunal, KCL applied to submit an amicus curiae brief, and it was accepted. So it was accepted even after the deadline. So this shows that the arbitral tribunal was really keen on hearing the views of amicus curiae. Now, we move on to Bywater Gulf versus Tanzania. It is this as well is like the first case. This is a water dispute, and the investor led the whole system in very poor condition. And what Tanzania did was terminate the contract. Tanzania, however, did not only terminate the contract, but it went further. It started with the deportation of the senior management out of Tanzania. It seized the company assets, and it installed a new manager taking over the business. There were different breaches that were found on behalf of Tanzania. And liability was found, but no damages were awarded. Why? This case is very interesting for the notion of full protection and security, but why is it relevant for us, for transparency provisions? Because, first of all, it welcomes the amicus curiae submission, and secondly, it tackles the publication of documents during the proceedings. We can read procedural order number 3 and procedural order number 5 of this case. In procedural order number 3, the tribunal decided that in the absence of any agreement between the parties, all parties must refrain from disclosing to third parties the minutes or record of hearings, any documents produced, any pleadings or written memorials, correspondence, and any disclosure has to get the prior approval of the arbitral tribunal. What can the party do? Can they talk in general about the case? Yes. Only generally. They can engage in public about the case, about general discussion, but not in a way that is used to antagonize the parties and to exacerbate the differences. What is extremely interesting about this case is procedural order number 5. Why? So here, it was discussed the presence to hearings. So Bywater Gove, the claimant, opposed to the presence to hearings. In fact, what did the claimant say? According to the claimant, the participation of amicus curiae was legally and factually irrelevant. Why? Because no environmental issues arise from determination in this case, nor issues of sustainable development are raised. And there is nothing that the petitioner could add regarding the issues that have already been raised by the parties. So this was the position of the claimant. However, what does the tribunal decide? The tribunal decides that this arbitration was raising a number of issues of wider interests, whose interest was going beyond the interest of the parties, but there was public interest. And what happened is that the tribunal specified the role of amicus curiae. So it said that the petitioner should not have the same positions as either party's lawyer. They should not suggest the arbitral tribunal how some issues or facts or law should be interpreted. And this gives a great help in understanding what is the role, what is expected by amicus curiae. The petitioners submitted a brief, and the tribunal referred to this brief in the award. So this was a very important, this is a landmark piece in transparency regarding the participation of amicus curiae. We finish with the last case, that is Bernard von Petzelt and others versus Zimbabwe, where, as we mentioned before, some indigenous communities have tried to participate in the arbitration as amicus curiae because they claimed that they had some interest in the land. However, what does the tribunal find? The tribunal finds that the petitioner's experience do not satisfy the requirement of a significant interest in the proceedings. So according to the tribunal, the indigenous communities did not have enough interest in the proceedings. But on the other side, the petitioners also were not even independent or neutral. And this is something that that the tribunal acknowledges. This is why the tribunal decides not to allow for the participation of amicus curiae in this case, because it does not want claimants to be unfairly prejudiced. So today we talked about transparency. We talked about the concept of transparency. We saw how it can evolve within the same case in Vattenfall versus Germany, from strict confidentiality until the broadcasting of the hearings. We talked about the advantages of confidentiality and why parties may choose confidentiality in arbitration. What do parties want, what they're looking for? But what are the advantages of transparency, especially when there is a dispute where public interest is involved? We discussed transparency provisions that are the availability of documents, publication of the award, public access to hearings, participation of non-disputing parties, and amicus curiae. And we dealt with these cases. To conclude, we can have 3 different levels. So at the treaty levels, in the current negotiation of investment treaties, we can see the rise of the ancestral transparency rules. Also, especially in the negotiations of the European Union. And the arbitral rules level, here we see the protection of confidentiality much stronger than in treaty provisions. And although some changes are actually happening. And finally, at the civil society level, we can see an increased participation thanks to the public access to hearings and thanks to the participation of amicus curiae. Thank you very much.
Thank you so much, Flavia, for this very interesting presentation. Indeed, transparency, as Flavia has pointed out, is a topical issue in investment arbitration, in treaty drafting, and we'll talk about this tomorrow. And especially in this moment where it's characterized by a backlash, so-called backlash against investment arbitration. Indeed, transparency, as Flavia pointed out, is very, very important for a fair, more efficient investment arbitration to stimulate public acceptance and understanding of investment arbitration. And this is underlined by the numerous initiatives that have been undertaken by many, many organizations in the field around the world. We see ancestral rules on transparency and also all the initiatives that have been undertaken by the European Union, both at the treaty, the drafting level, and in the investment proceedings, how they are structured. So, thank you again. Thank you all for coming today. One last question that we might have a take-home question, so that does not require any answer. And so, how much transparency is indeed a very important principle in investment arbitration, but how much transparency is really needed in investment arbitration? If you might want to think about your home jurisdictions, so proceedings in arbitral courts, they are equally important for the public, are not that transparent. They do not, in most cases, foresee unfettered transparency. So should we aim at the utmost openness in investment arbitration, or are there boundaries for investment arbitration? So thank you all again. Thank you, Flavia, and we'll see you hopefully tomorrow. Thank you.